having been made in this behalf. So they also, my lord, mention bride and bridegroom. My lord, kindly now turn to, my lord, just as an illustration, my lord, Indian Penal Code. Man and woman are defined under section 10, my lord, 140 at the foot. Section 10. The legislature knew what is the meaning of male and female. Well, then section 100 and well, item 114, section 304B, where the death of a woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband, or in connection with any demand for dowry, such death shall be called dowry death, and such husband or relative shall be deemed to have caused her death.
So suppose a lesbian woman in a relationship.
It, my lord, 375, if your lordship sees at page 142, it applies only to males. And please see, my lord, I will not read. A man is said to commit rape.
142, is it over here?
Yes, my lord, page 142, section 375, definition of rape. Because only man can be guilty of this offense, my lord.
A man is said to commit rape.
And further, my lord, a man is said to commit rape if he so and so.
Right. Meant something else. If a man, and here I'm not talking of same-sex relationship. If a gay man rapes another man, it is not rape.
IPC, this is that.
That would be 377,
7.
which is, my lord, now which goes.
No.
Without consent is there. Yes.
But then
Still consent 377.
Yes. It is. I stand
I
corrected.
think there is a change in there's a difference in the expression, of course, definition, but even the penalty also.
Yes, your lordship, it's only consenting same-sex people.
Situations on men also. They are completely, inapplicable.
But in case of lesbian marriage, my lord, possibly this may not apply. Possibly. No, my lord, it may apply if we read man to be woman.
Disparity.
375 B.
Right. Definitionally, it is
B. If we read man as woman also, then it may apply. Otherwise, the intention is to punish man. That's how it.
Was a definition of.
Yes. Otherwise, a woman can be guilty, my lord, under B or maybe under C. Provisions, abatement to suicide under the Evidence Act. If a woman commits suicide, there is a presumption against the husband.
Right.
So again, my lord, we will have to see, my lord, who the person is. But the major problem is in Code of Criminal Procedure. My lord, page 144. Arrest how made. Lord, take a homosexual couple, both man, but one playing the role of a woman. Arrest of how made. Save in exceptional circumstances, no woman shall be arrested after sunset and before sunrise and where such exceptional circumstances exist, the woman police officer shall, by making a written report, obtain the prior permission of the judicial magistrate of the first class within whose local jurisdiction the offence is
Because in
committed.
a case of a
It is decree, and decree is to be executed even under the Special Marriage Act. Therefore, I pointed out section 39A, that decree of judicial separation or will be executed as. There also, my lord, the word is female, male, husband, wife, etc., etc. My lord, I am not duplicating. Your lordships can, my lord.
I think we can conclude this part of the analysis.
My lord, there are, but again, my lord, even if illustrative list is 150 sections of various other statutes. So therefore, my lord, in my respectful submission, your lordships may not give the meaning, my lord, which creates complications then solving the problem. My lord, maybe if Parliament considers appropriate, Parliament may, in its wisdom, my lord, provide for a comprehensive legislature. And as I have pointed out yesterday, wherever other legislative bodies have done it, they have suitably amended other allied laws as well.
All right.
Maybe by the amending act or by one act, my lord, whichever.
Now, what is the next point?
Now, my lord, next is Gaidan, my lords.
Next
Kindly
point?
come to page 78.
Gaidan, okay.
Gaidan.
Yes, yes.
Which page?
My lords,
Volume?
82.
The other part.
The same.
Page 82.
कहाँ पर है गैदान?
82 कह रहे हैं।
Lordships need not read.
Yeah.
Page,
82.
I'm sorry.
Same note one.
Note at this stage, your lordships need not read. I am also not reading. Page 63 to 82, I have produced relevant parts of the judgments which says that in the process of interpretation, your lordships would not interpret contrary to the intent, would not change the structure, would not tamper with the architecture, etc., etc. These are the
right.
propositions are well settled. I'm not, but these are the page numbers.
You
Now,
also
please.
quoted Lord Nichols.
Yes.
Quoted Lord Nichols
Yes.
extensively.
Extensively, my lord. Because that still continues to be a leading judgment on, my lord, how, where the process of interpretation ends and where the procession of legislation begins. Lord, 78. Lord, I'm sorry, page 82, PDF 82. Lord, the significance is, please, my lord, consider this. In Britain, your lordships are aware the House, Parliament is sovereign, it's supreme. There used to be no judicial review the way we understand it, to declare a provision to be unconstitutional. What they do is non-compatible, incompatible. That's how, my lord. That was introduced, my lord, by way of Human Rights 1998 Act. Gaidan, my lord, in my respectful submission,
Yes.
yes, my lord, kindly, my lord, allow me to read this, my lord. Gaidan, because the reliance is misplaced without giving the background and the context. Please see, my lord, further. Apart from the absurdities that the said principles as canvassed by the petitioner may lead to, it is necessary to also settle the issue raised through the judgment of Gedan. It is submitted that reliance on the said judgment is wholly irrelevant to the present case for the short reason noted as under. The system of judicial review in UK and the system of judicial review in India are starkly different. Prior to the enactment of Human Rights Act 1998, there was no judicial review of legislation in UK. Specifically, Section 3 of the HRA 1998 empowers the UK domestic court to reinterpret or force through treaty obligations under the European conventions in local statutes. In Gedan, the court was dealing with an entirely different subject matter of an enactment dealing with rent and not of creating a social institution in the nature of marriage. It was a question of a singular provision to be read in consonance with the treaty obligation and not the case wherein the entire architecture
Yes, please go.
Lord, Gedan was not dealing with, my lord, an interpretation which affected several multiple statutes. But now see the difference in powers available to the court, my lord, in UK and in India, my lord. A bare perusal of HRA, which for the first time in UK provided something akin to judicial review of legislation, would make it clear that the said legislation and our constitution operate very differently in terms of mode and the result it seeks to achieve. The relevant provision of HRA are as under. My lord, then 1 I can skip. Kindly directly come to 3 at page, my lord, 83. Interpretation of legislation. This is a kind of judicial review which is available, my lord, in UK, which is complete, my lord. Therefore, they say that Supreme Court of India is the most powerful court of the world, because your lordships can strike down the provision also as unconstitutional made by the competent legislature. Interpretation of legislation. So far as it is possible to do so, primary legislation and subordinate legislation must be read and given effect in a way which is compatible with the convention rights. But so far as it is possible, it's not a mandate of law. This section applies to primary legislation and subordinate legislation whenever enacted, does not affect the validity, continuing operation, or enforcement of any incompatible primary legislation, and does not affect the validity, continuing operation, or enforcement of any incompatible subordinate legislation if, disregarding any possibility of revocation, primary legislation prevents removal of the incompatibility. You declare it, nothing beyond that. It continues not only on the statute book, it continues to operate also. That, my lord, comes in further sections. Declaration of incompatibility. Subsection 2 applies in any proceedings in which a court determines whether a provision of primary legislation is compatible with a convention right. If the court is satisfied that provision is incompatible with a convention right, it may make a declaration of that incompatibility. Subsection 4 applies in any proceedings in which a court determines whether a provision of subordinate legislation made in exercise of power conferred by primary legislation is compatible with a convention right. If the court is satisfied that the provision is incompatible with a convention right and that, disregarding any possibility of revocation, the primary legislation concerned prevents removal of incompatibility, it may make a declaration of that incompatibility. A declaration of that, this section, under this section, a declaration of incompatibility, please mark, does not affect the validity, continuing operation, or enforcement of the provision in respect of which it is given, and is not binding on the parties to the proceedings in which it is made. It's kind of an advisory jurisdiction. It's as they say, my lord, jurisdiction to nudge the legislature. And my lord, I have also pointed out that after Gedan, even the courts in Britain have taken, my lord, different view, my lord. Now, your lordships may kindly see in Gedan, my lord, para 148, I have quoted Lord Nicholas. In this context, kindly read, my lord, my learned friend said that now after Gedan, whatever you want to read, you can read into the provision and even alter the statute. That was, my lord, the tall argument which was made, which is, my lord,